welcome to today's CRISPR Ownership Disputes, Current Status, and Future Prospects live MBHB webinar. My name is David, and I will be in the background answering any WebEx technical questions. If you experience technical difficulty at any time during this WebEx event, please submit your technical issue in the Q&A panel, and I will assist you. Please note that as an attendee, you're part of a larger audience today. However, due to privacy concerns, the attendee list is not displayed. All attendees will be in a listen-only mode for the duration of today's call. And as a reminder, this call is being recorded. With that, I would now like to introduce your speaker for today, Kevin Noonan. Kevin, you now have the floor.
Thank you. Good morning, everyone. Thanks for coming. Just so you don't look under, unfortunately, this says August 20th. It's really August 18th. I've been doing that all week. I'd like to tell you about CRISPR because it's a fascinating thing, but first we have to do some housekeeping. Please note that all registrants for today's webinar will receive an email from MBHB, the lovely and talented Joe Milligan, within 24 to 48 hours containing a PDF copy of the PowerPoint. So don't worry about not being able to write stuff down because, frankly, there's a lot of stuff in these PowerPoint slides, and you'll have them for your reference. There'll also be a link to the archived audio version if you want to hear me talk about the slide to refresh your recollection. For those participants seeking CLE credit for today's presentation, please note we have put two randomly placed PowerPoint slides inviting you to repeat a simple online poll question. It is simple, and it's random even for me. I'm not sure where it is. You must complete both of them in order to confirm your active participation and be eligible to receive CLE credit. We encourage you to submit any questions you may have during the webinar using there's a WebEx online question submission module. I'll try to get to them if time permits. If it doesn't permit, we have all your contact info, and I will get back to you by email after the webinar is over. All right, so let's just give you a little bit of a roadmap. There we go. We're going to talk about background. I mean, CRISPR is one of those things that everybody talks about it, and yet it's complicated enough that going over is probably a good idea. Also, the other bit of arcane minutiae we're going to talk about today are interferences, which are really a lot of fun to do. Unfortunately, of course, as you all know, since 2012, the ability to have an interference or anything that was filed and didn't claim priority prior to 2012 has disappeared as we became a first inventor to file country instead of a first to invent country. And we'll talk a little bit about interferences because we're going to talk about two interferences today. The first one from 2016 against the Broad and their colleagues and the University of California at Berkeley and their colleagues that ended with a decision that there was no interference in fact. And then we'll talk about the new interference, which was instituted about a year and a couple of months ago. Same thing, the Broad's contentions in that interference as well as California's. Then they had oral argument in this, and then we'll talk about the implications of all of that. Oops, wrong way. So, CRISPR technology. Here's what it stands for. Clustered regularly interspersed short palindromic repeats, which is why everybody calls it CRISPR. You may remember back in the day, Cohen Boyer and their friends and colleagues and others discovered the restriction of the nuclease system, which was a system produced by bacteria that would recognize specific, usually short palindromic repeats. We'll see palindromes here as well. Palindromic repeats, usually when it was first started, 6 repeats, and they're palindromic because the sequence, for example, if it was GAT, it was then ATC. So it was a mirror image on either strand. Those were very useful, and sort of analogously to what happened here with CRISPR, they were used, when purified, to be able to specifically cleave DNA at these sites that occurred in any DNA, not just bacterial DNA. And because they left short, usually 4 base overhangs, they could also be used to tie things together, ligate them up, and if it wasn't for restriction enzymes, we probably would not have had the whole recombinant DNA technology that fueled the biotech industry ever since. Well, this is like that, but more complicated. It's an immunity system. It's a way for the bacteria to be able to protect itself from infection from viruses, and these viruses are typically called bacteria phage. Comes from a long time ago, 40s and 50s, but they're viruses, and they're usually injected into the cell, and then they take over the cell. And make the cell make lots more of them, and the cell bursts apart, and that's that for the cell. So the cell, to protect itself, besides having these restriction enzymes, have this CRISPR-Cas system. There's an endonuclease called Cas9, and that's the one we'll talk about today. But really, there are lots of Cas endonucleases that are out there that can do slightly different things. And you have the actual protein components, and then you have two RNA components that's important. You have the CRISPR or CRRNA. It's also sometimes called the guide RNA. The thing about that is it's specific for bigger DNA sequences. Then you have the transactivating RNA or the tracer RNA, and that tracer RNA is part of the structural integrity of the way the molecule forms itself. And in the bacteria, there are two different species that are made. Oops. Come on. Okay. Why is this not? Sorry, I'm just being inept here. There we go. Okay. So just the cartoon in the bottom right explains what I just said. This is the way phage infect bacteria. Now, these are particular kind of phage. They're always great. They look like the lunar module. But they inject their DNA. The DNA takes over the cell, replicates, forms more of its phage heads, and then bursts open the cell. And you can see in this particular cartoon I have in the little red skull and crossbones, there are a bunch of places where the bacteria can protect itself. It can protect itself from not letting the phage bind or letting it inject its DNA or letting it make the phage heads and all of that. But there's a little scissor that is there. It's kind of in the middle, and that's kind of what happens here. What happens is that the Cas9 protein is able to recognize particular portions of the phage virus DNA, and there's usually, I think it's GGN is the sequence, and it cleaves a short piece above that and integrates it into the DNA, in fact, in the specific region called the CRISPR array. And the CRISPR array is characterized by having repeat sequences interspersed with novel sequences. They call them spacer sequences for historical reasons, but they're in fact little pieces of the virus. And every time the bacteria who has a CRISPR-Cas9 system, when they don't all do, gets infected, that little piece gets integrated into its genomic DNA. So the next time that kind of phage infects, it can readily make, and I'll have a cartoon about that too, readily make the CRISPR-Cas9 system that can cleave, that can break up the virus DNA and protect the cell from infection. And so you actually have a history of what viruses have infected the particular bacterial cell that you have, and of course it's heritable, so all of its progeny get that as well. So this is just a more of a cartoon how that works. There's the array. You make this spacer, and of course it makes the whole thing. Then it chops it up, and you have these little activator RNAs, CRRNAs, which bind to the Cas9 protein, and then that guide RNA complex essentially puts the endonuclease, the CRISPR, because that's what it is, the Cas9 endonuclease, at that site in the virus and cleaves it. And by doing that, it stops the virus from replicating and essentially acts as the immunity. So that's what happens if you are a virus. The brilliance of Dutton and Charpentier, they realized that, that guide feature is something that we could use, put together, and if we did it inside another cell, a heterologous cell, I think that not all bacteria have the CRISPR-Cas9 system. I think B. subtilis doesn't. So they weren't thinking what kind of cells. Like you could put it in a cell, and that guide sequence, which you could choose, could go to any part of any DNA you want, including the chromosomal DNA, using that term chromosome to include bacterial chromosomes as well, and it could essentially have you snip out a piece of DNA or put in a new piece of DNA. And as you can see from this cartoon, you can go into for gene therapy, you can go into mice, you can go into cells, anywhere you can get this in, right? And of course, and this is important. Remember, I told you that bacteria have two sources of this tracer RNA and the guide RNA. Well, they also realized you could fuse them together because really it doesn't matter as long as they are in the right conformation. And by doing that, besides making it easier, you can make sure that you have the entire functional CRISPR-Cas9 complex made. So here's what you can do if you have this one way on the left, is you can have the CRISPR-Cas9 system come and cleave the DNA in particular spots and then put them together at each end, what's called non-homologous end joining. Essentially, imagine you just snip it out. If there's a gene you don't want, you can put it in, and that part of the DNA can be removed, and you're done. However, if you want to introduce a gene or put in a change gene, say there's a mutant gene in the cell and you want to put a non-mutant gene, you can put in another piece of DNA with that, and by homologous recombination, you can now insert a new piece of DNA at a particular spot, and it's the particularity of insertion that's important. As much as the restriction in the nucleases were good, those restriction enzymes occur at a particular frequency just because they're short. This is specific, the same way that we have specific primers for PCR, polymerase chain reaction, that enable you to make particular pieces of DNA, and all of the CSI folks in the world were happy about that. You have, in this case, a specificity that you can target exactly where you want the new DNA to go into the chromosome. And the one thing that I'll say here is that the Broad, its colleagues, Zhang, George Church, and friends, they were the first, at least, to publish and actually use a CRISPR-Cas9 to edit eukaryotic DNA, although I'm not saying that the contemplation of that was not something that Doudna and Charpentier hadn't thought of. In fact, their contention is that they did. But the person to actually do it were Zhang and friends. So, who are these folks? Well, Jennifer Doudna and Emilien Charpentier. In fact, Jennifer anyway, I'm not sure Emmanuel's on it, has a book that I recommend. It's a pretty good book. And in fact, I was just on listened to a panel discussion from Cold Spring Harbor yesterday, that there's a book, I think there's a film, I think it's called Natural History, is going to be on Nova, I'm going to plug her, going to be on Nova, I think September 8th, and on Netflix October 1st, about more, not about how CRISPR was developed, but more its potential uses for all sorts of things. So that's just a page from from Science, and then here's a paper by Zhang and friends in the Broad explaining how you could do this sort of genetic engineering doing CRISPR-Cas9. These are all the patents that were in the first interference, and I just put them here to have it in one spot, and you can see that the Broad, and to explain that the Broad was very diligent in getting its patents. I mean, I think it did fast-track sort of filings. It really jumped on this and got all these patents very, very quickly, whereas Berkeley and friends had this patent application at the time of the first interference, and it took till the first interference to get it allowed or get it in condition of allowance. All right, I promised you a little bit of interference. I won't belabor you with it, but I think in order for you to understand what I'm going to talk about the rest of the webinar, we have to go over this a little bit. So pre-AIA, and that means any application that has a pre-AIA filing date, can be eligible to get itself into an interference that determines who was the first inventor. Because as a first-to-invent country, you either did or you didn't. I remember I had one interference once where literally the filing dates were within less than a month of one another, and we went back and the conception dates were within less than a month of one another, as were the reduction of practice dates. So sometimes these things can be very close in time. The interference is declared in one of two ways. One is the office determines, because one of the things that they did and probably still do if it comes for those sorts of applications that have the right filing dates, it will check to make sure there's no interfering application or interfering patent that's out there, because they don't want to issue two patents on the same thing, and it's a check on that. And also, I mean, I've seen circumstances where you'd get a letter from the patent office that said, your claims are in condition for allowance, but there's another application out that we have that, if it gets its claims in condition for allowance, would be interfering with your application, and so we're suspending prosecution for usually 6 months, because lots of reasons why the other person may not be able to get their claims in condition for allowance or will abandon, in which case your patent gets it granted and you don't care. But that was sort of a check that they always did. The other thing that can happen is that the applicant, who knows about there being other patents or patent applications before the office, and this, of course, has gotten much easier ever since patent applications were published, can what's called provoke an interference. They can essentially file a paper that will identify the intended target and will point out how these claims of theirs that are in condition for allowance, because that's a requirement, would be interfering with or would be claiming overlapping subject matter with whatever the patent or other application is, and essentially ask the office, give them a heads up, if you will, ask the office to declare the interference. When the office does declare an interference, what they tell you in the declaration is who are the parties, and sometimes it can be more than 2 parties, it can be 3 or even more, what patents and applications are involved. They have something, an artificial claim-like looking thing that isn't a claim called a count, and that count defines what the interfering subject matter is. And then they tell the parties which of their claims correspond to the count, so they know which of their claims are at risk. The rules are at, if you care, 37 CFR Section 41. One party, and this is important for interferences, is designated as the senior party. And the senior party is just done, or the designation of senior party is just done on the paper record. Who has the earlier priority date in the patent office? That's the senior party. It doesn't mean that is the first to invent. It means that that's the senior party, and the beauty of being the senior party is that you don't have the burden to prove priority. The other side, the junior party, has to prove priority, make out a prima facie case of earlier invention, and then you can rebut it as the senior party. But as senior party, you can just cross your arms over your chest and say, yeah, you didn't do it. It's risky, but you didn't do it, and you have to say boo about it, and you can still prevail. Now, the way interferences work is there are 2 phases. The first phase, the motions phase, which we'll spend a lot more time on because there's been no priority phase in either of these interferences as yet, is where you essentially can try to get the subject matter of the count and the way things are positioned in your best interest, in what's good for you. So, for example, you can change the count based on what you call your best proofs, because you actually have to prove up that you have a claim that corresponds to the count at your earliest priority date, and so you can ask to have a slightly different count, and we'll see that in the second interference. You can also move to remove or add claims. Usually you move to remove your own claims and to add your opponent's claims, but you can ask the office to designate other claims as corresponding to the count. You can challenge other parties' claims on validity grounds. Typically this is done when there's someone who provokes an interference and the other side will say, well, they didn't satisfy 112, because generally the idea is that they kind of manipulated their claims into something that looks like yours, and if they can't support it by 112, then that is almost a threshold issue. You can prevail on that basis. The other thing is if you do make 102 and 103 arguments, the office has a sauce for the goose rule, where those patents and those whatever priority you assert will be applied to your claims just as well, and the presumption is that they invalidate your claims as well. You can ask for benefit priority in earlier applications, or you can declare there's no interference in fact, and that's important because that's what happened in the first interference. That means that, in fact, and we'll talk about why in a little while, the office was wrong in declaring the interference. And when the office is wrong in declaring the interference, it's almost like they lose the institutional right to be able to adjudicate because there is no interference, and that's the only basis for them to make the determination. When all that's over, there's a priority phase. The priority phase is when the office determines who was the first to invent. And as I said, the junior party goes first and has to provide their evidence of why they were first to invent, all the laboratory notebooks and all that sort of stuff that people usually associate with interferences. That's where that happens, is in the priority phase. So now we have an attendance tracking, and for purposes of making sure you get CLE credit, which we want you to do, you have to put the word patents, small p, I guess, into the WebEx poll. And so you have 45 seconds or something to do that, and 45 seconds is a lot longer than I ever think it is. So interferences, I will tell you, are and always have been a lot of fun, because they are a place for prosecutors to, for instance, argue before the PTAB. They are incredibly arcane. The PTAB, to be kind, has its own way of interpreting the law, and so it helps to get into their rhythm to figure out what they think is important and how to best make that argument, and to convince them that you should prevail. And that feels like 45 seconds, so I'm going to move on. So the first CRISPR interference a couple of years ago. So it was declared on January 11, 2016. And the senior party was the Broad, MIT, and Harvard University, and I'll just call them the Broad, whereas the junior party was the University of California at Berkeley, the University of Vienna, and Emmanuel Charpentier, and not so much in the first action, but in the second interference, abbreviated all over as CVC. Now, pretty much all of the Broad patents were involved, and that notation here is essentially a reproduction of what I put in the earlier slide. All of those, I think it's about 10 or 12 patents, are at risk. And that's the important thing to remember. And interference puts your patents at risk, because if you lose, your patents are invalidated because you weren't the first to invent. And that can be, devastating. I think some people probably recall that earlier this year or late last year, the European Patent Office determined that there was a problem with inventorship and the applicant status, and some of the Broad's earlier European patents were invalidated. And rightly, people said this is a problem. Well, this is what the Broad was looking at when this interference was declared. California had one patent application. They had all these patents that they'd worked enslaved to get. Now, this is the interference count. I don't want you to read this whole thing, okay? But the important thing here to recall when you think about this is it's a method claim, and it's limited to a eukaryotic cell, right? Because a lot of the rest of it is the same, cleaving or editing, all that, right? But it calls out a DNA targeting RNA that comprises this target RNA or guide sequence and an activated RNA or tracer sequence. Now, I'm pretty sure that this one doesn't say that those things are fused together. Using a target RNA and an activator RNA just says what they do. The guide sequence hybridizes the target, and the activator hybridizes to make this double-stranded RNA duplex that can enable to bind it to the Cas9 protein, and that's all it says, right? The Broad's claim said, and this was also, is now not to a method, it was to a system, and that was the first regulatory element is essentially, for want of a better word, the promoter that drives this to make the guide RNA, and the second one is to make the CRISPR, the Cas9 protein. And so that's the claim that the Patent Office determined corresponded to the count, and this is California's, which is a method claim, and very similar. But here they say a single molecule DNA targeting RNA comprising, depends how you interpret that, but again, the target RNA and the guide RNA and the tracer RNA. Okay? So what happens? I talked about motion practice before the office, and the first thing that the Broad argued was there was no interference in fact, and we'll talk a lot about this. I'm not going to belabor it. The other thing I want you to keep in mind is you don't get to file these motions of right in the Patent Office anymore. The board will determine whether they're going to permit you to do so. The granted and denied notations I have on some of these motions are reflect that. So, okay, no interference in fact. That's the first motion, actually. It's motions 2 through 13. Broad filed a lot of motions, and given all of the patents, et cetera, you can see why. There were 33 motions that involved a dozen patents that the Broad deserved the benefit of priority to 16 different provisional applications, and the board said, yeah, you can file a motion, but 4 applications at the most. There was one, again, the university's claims are unpatentable for failure to satisfy the written description requirement. There was another one that unpatentable for lack of enablement. There was another one that was the university's claims are invalid for certain prior art, and then a motion for access to the prosecution history of the unpublished applications, because I think the Broad thought that if there were applications where, given that its argument there was no interference in fact, if in fact California and friends were trying to get a claim to eukaryotic cell-directed CRISPR, then they would want to wrap those applications into this interference just so they wouldn't have to do it again. As it turned out, that didn't happen. The board essentially imposed the responsibility, so they denied that motion. The thing to keep in mind is that the distinction the Broad made in the first interference, and makes to a certain extent in this interference, was that, first of all, the California's claims were not directed to eukaryotic cells, and California didn't enable or describe using CRISPR for eukaryotic cells, and remember, in its application. So that was what the junior party, California, said, first of all, right off the bat, again, the same way, no interference in fact, these are invalid. because the university had an application that was published, and the contention was that the way the Broad filed, because most of these, as you'll see, were continuation applications, the way the Broad filed its application contravened the provisions for retaining your pre-AIA filing date, and so they weren't available for interference and invalid because this earlier publication would have invalidated them. And I don't know if you remember, but when the AIA first came along, there was a very interesting worry. I think it was Section 3N or something. I remember talking to Janet Gongolo, who was the person in the Patent Office implementing this, and it was a very sort of dance, if you will, of doing it correctly so you didn't fall into this trap. Well, California said that they did. There were 5 motions to change the count, and it was granted as to one of them. And by the way, that motion of invalidity was deferred, and that happens a lot. The motion to give the university priority benefit to its earlier applications was granted. Again, this is just granting you the right to make the motion, not to grant the motion. They deferred the anticipation argument that against the Broad's claims. They deferred obviously double patenting, the same thing with improper inventorship. They denied an inequitable conduct charge. They almost always do that. And each party filed the motion for judgment on priority, which they do almost as to make sure that nobody forgets the fact that they're also asking for judgment on priority, even though priority will happen in the priority phase. So what happened? Well, the board didn't render any decisions on any of the motions we just talked about, except the motion for declaration of no interference in fact. And as I said, I think before, that declaration there was no interference in fact ended the interference because it's jurisdictional. The only authority the board has to decide who is the first to invent happens if there's interfering subject matter. And so based on that, there was no reason. In fact, you could argue that it would have been improper for the board to render any decisions once it came to that conclusion. Now, and for where did everything stand at that point? Well, the board got to keep all of its patents, and all of its claims and all those patents had been determined not to have been invalidated based on earlier invention by California. And that was a big deal for them to prevail. And you'll see that was such a big deal, that is essentially their argument in the second interference. And the other side of the coin is that California and folks will be able to get their patent, which was not limited to eukaryotic species, they would be able to get their patent application granted and have a patent on that, which obviously raised the issue that we'll talk about a lot of having to have 2 licenses. So why did the Patent Office decide this? Well, the way this works is, according to this citation of the rules, that an infringement will exist if the subject matter of one party's patent or disclosure, if in the prior art, would have anticipated or rendered obvious the subject matter of the claim of the other party, and vice versa, and it's the vice versa that matters, okay? Now, the Broad had the burden of proof. The thing about these motions is whoever advances the motion has the burden of proof on that motion. Everybody agreed here that they said, look, either the Broad's claims wouldn't anticipate or render obvious California's claims, or California's claims would not render or anticipate the Broad's claims obvious. So that was the task, and everybody agreed that California's claims didn't anticipate the Broad's claims because California's claims didn't encompass specifically eukaryotic cells. And so it came down to obviousness. And the question really was, what are the Broad's claims obvious, which were limited to the practicing of CRISPR in eukaryotic cells, if in light of and assuming that California's application and its disclosure were in the prior art. And the reason that the board decided this, or this quote here, and if you think about it, and think about the cartoon that I had earlier, if you introduce CRISPR-Cas9 into a bacterial cell, then the bacterial cell being what it is, you can see how that would work pretty expeditiously. If you introduce it into a eukaryotic cell, you have to actually make Cas9, and it has to properly fold and all that. It has to be made in the cytoplasm and then go back into the nucleus, where the guide structure has to be able to hybridize with the target DNA that you're looking for, which You may not have the chromatin may be compacted where you won't be able to get to that, or maybe only during replication. There's all sorts of other things, pH and ion concentration, all of that. But these are all things where a prokaryotic cell differs from a eukaryotic cell. And so because of that, the board said, okay, we don't think it would be obvious. Now, some of that, unfortunately, for California, some of that evidence came from contemporaneous statements by California's inventors that just said, well, we think it'll work in eukaryotic cells. We can't see why it wouldn't, but we're not sure. And these are all things that academic scientists say when they're being careful, and unfortunately, sometimes they say it in print. And so this was prior art that was able to be used. And the board said, well, California's argument was, wait a second, these are statements by the inventor, people of greater than ordinary skill in the art. Why should they shouldn't count, essentially. The standard is one of ordinary skill in the art, and the inventors almost should get a pass because they're the inventors. And the board turned that around on them and said, well, by the same token, if they were uncertain as the inventors, people of extraordinary skill in the art, then certainly the test has been satisfied that someone of ordinary skill in the art would not have had a reasonable expectation of success. And the fact that, as California mentioned, that many other groups, including the Broad, actually got the system to work in eukaryotic cells after California published its own and filed applications on its own CRISPR-Cas9 invention. That didn't matter because it can work. Things that happen afterwards can show that you didn't enable something, but if it's not prior art, the person of ordinary skill in the art did not have any of that information, and the question is that person's reasonable expectation of success, which the board said they wouldn't have had. So I went to the Federal Circuit, and of course the Federal Circuit affirmed because, remember, this is in the Patent Office, and the Patent Office gets its deference under Dickinson v. Zerko for findings of fact, for things that are based on fact. And everybody knows obviousness is a mixed question of law and fact, but that's exactly right. It's a mixed question, and this is the factual part. And the standard is substantial evidence, which the board the Patent Office said the board certainly met that standard. On top of that, there was expert testimony that the Broad put in as part of its motion, and that expert testimony showed that many experts said that there were so many possible ways it might not have worked. This is very much a across the Rubicon type of experiment. You can think it might work, but you really can't expect one way or the other whether it will work until you actually do it and show that it works. And that was kind of the situation that they were at. And so the Federal Circuit said that this evidence, this factual evidence, supported the board's conclusion that the skilled worker would not have had a reasonable expectation of success, that it would have been unpredictable to that person of ordinary skill in the art that this would work in eukaryotic cells. And under those circumstances, the Patent Office was perfectly right in deciding that there was no interference in fact, and if there was no interference in fact, the interference was dissolved, and that was that. Okay? So, again, for the Broad, this is great. It permits them to retain a very robust patent portfolio, and we'll see a little bit later, but not in a lot of detail, but there'll be a slide you can study at your leisure, that the Broad, as has California, has licensed this technology widely, and the part of the CRISPR universe that their patents give them exclusivity in is the part that probably most people care about. Therapeutic applications, agricultural applications, animal husbandry. I mean, these are all eukaryotes, even to the point of making a better yeast to make wine would be something that would fall in the scope of the Broad's claims, given that there was no interference in fact, and so they get to keep that. Now, on the other hand, California was entitled to get very broad applications of CRISPR that had no limitations on the cells in which you use it. So think of it as genus species almost. And what that would mean is that if I were a licensee of a Broad patent and I was practicing this, I would at least have a trepidation that California would knock on my door one day and say, well, it's all well and good that you have a patent or you have a license to a patent from the Broad, but you need a license to our patents as well. As everybody knows, patents are a right to exclude. They don't give you an affirmative right to do anything. And so under those circumstances, California could come and ask for another license. And that I mean, for a lot of reasons, that's a bad thing, not just the commercial application, but the fact that is this going to retard adoption of the technology? Is it going to keep it from coming to fruition, all of that? The other thing that I think we need to remember is that even though most of the motions, in fact, all the juicy ones, were not briefed because the PTAB didn't give either party the right to have a party file a motion about what how the prior art could be applied or what the problems with enablement or written description were and all of that, and in fact didn't rule on any of the motions. But it certainly gives you pause if you're either of these parties that these allegations were made, and so there are validity and unenforceability issues that could come up later in litigation if a licensee threw up his or her hands and said, all right, you guys can't work this out. I don't think I need a license for each of you because your patents are invalid given what you've said about each other, and I'm going to take my chances. I'm not recommending that, of course, but I'm saying it certainly does suggest that there are at least Achilles something, maybe not a heel, that would be a problem for both parties' patents. And again, it's just a hint. Okay, so that's where we stood and until last June. And while we were thinking about all that, California pursued claims that were specifically directed to eukaryotic cells. So, okay, if there's no interference, in fact, with the application that we have on file that doesn't mention eukaryotic cells, we're going to file a bunch of continuation applications that do mention eukaryotic cells. In fact, that's what they did. And this was not a provoking interference situation as much as the Patent Office realized that once these became in condition for allowance, knowing about the interference that they had done a couple of years earlier, realized that this was also something for which there should be interference, and in fact declared it last June 24th. Again, the senior party was the Broad, MIT, and Harvard, and the junior party were California, Charpentier, and the University of Vienna. Once again, pretty much all of the Broad's patent portfolio was put into this interference. There may be, I think there's at least one other application here that wasn't in the earlier one. And now there were quite a few more California applications, almost a dozen there as well, that were now part of this interference. And this is the count, and this is something, just to step back for a minute, one of the things that the office started doing within the last 10 or 15 years is rather than coming up with their own count, they'll say the count is either a representative claim from one of the patents, and this is the 359 patent, claim 18. So again, it's a Cas9 system that has the CRISPR Cas9 protein, at least one guide RNA that encodes in the eukaryotic expresses one gene product, et cetera, et cetera. And here, an express limitation where the guide RNAs can provide a guide sequence fused to a tracer sequence. So here we do have the fusion language. And then you have Claim 156 of the 807 application. And again, you have very similar here, a single molecule where you have the targeted, the guide RNA and the tracer RNA. Okay? So that's the count. And the claims corresponding to the count is that they all the claims in both the Rhodes patents and CVC's applications correspond to the count. These are representative claims. No party is given any priority benefit. It's just on the earliest priority date on the papers in these patents and applications. And in this case, the Broad is senior party, if only because all of these patents were filed in the fall of 2018 for California, and so the Broad almost has to be senior party here. Now, this is motion practice. The jury, the junior party, they asked for an expedited motion for benefit of their earlier applications and to redeclare the interference with them as senior party. Well, they didn't get expedited consideration, but they were allowed to do it. Keep in mind that the first green box is the 859 patent. All of the applications in interference, all these yellow patents, all are continuations of and have the same specification as these three patents. Now, keep in mind that interferences only work application to application or patent to application. You can't have patent to patent. So these three patents can't be part of the interference against the Broad's patents. But the important thing are these four blue boxes at the top of this figure, because those are the applications, the earliest which goes back to May 25, 2012. Those are the provisional applications for which California is asking the board to declare that they have priority. So this is just so you have it. They want benefit of priority. essentially one motion for priority, and this is all the applications that they are involved and that they think they're entitled to. I don't know why it's motion 3. Somehow motion 2 got lost. Wanted the board to treat those claims under the AAA with regard to Section 102 and 103. This is essentially something we saw in the earlier interference, that they're unpatentable over, now this makes it also interesting, over an application to Sigma, because now Sigma Aldrich has, in fact, an application that it has been trying to get in condition for allowance for quite some time, because its position is that their patents should be part of this interference as well. And they have a pretty early priority date, or at least when they go back to an early pretty priority date, which hasn't happened, but the board said both deferred both of these two things, these two contingent motions. Another motion for judgment of unpatentability under 102F and 115A for failure to name the inventors and the alleged invention. This is something we saw before, a misjoinder of invention motion. That was also deferred, not part of this interference. And inequitable conduct, again, denied. And then a miscellaneous motion to add these other CVC applications. I think usually you try to not have all your applications involved. I think the idea was that CVC has determined this is the hill they're going to die on. This is where they want to get this thing resolved, for better or worse, not leave any opportunity for any further interference challenges. And so the PTAB, rather than granting a motion, just redeclared the interference, only change was including these 4 applications, and so they denied the motion because it was moot. The senior party, for the Broad, on the other hand, first motion, and the theme will be all through their motions, judgment based on interference estoppel. And we'll talk about Rule 127, which I will read to you because I don't have a slide, unfortunately, is their basis. And this was granted on an expedited basis, essentially one brief for these 3 motions, 1, 2, and 3, because the other argument they made was not just this interference estoppel motion, but also a motion that said the rules say that you, CVC, if you wanted to pursue the eukaryotic claims, it was your responsibility in the first interference to make sure that those claims were part of the interference, and you didn't do it. And therefore, the argument they make, as you'll see, is that you didn't do it for strategic reasons. And because you didn't do it, you lost your opportunity. It's inequitable for you then to make us go through this interference, and you should dissolve it. Also, they wanted the board to issue a notice to show cause of why the interference wasn't barred by the judgment in the 048 interference. The reason the rest of these motions are contingent is because if the board did not rule in their favor on the first 3, then a contingent motion to substitute the count. Again, the standard is it has to be broad enough to cover the board's best proofs, and that was their argument, and they were granted that motion. And this is the count, and again, it's too long to go through the claim. But basically, it's without the fusion part, because they have one where they're fused. And the idea is if you substituted the present count for this one, these claims, and you can read them, these 4 patents are the only claims from the road that will be left in interference. And strategically, this is exactly what you want to do when you file a motion like this. If you can get the office to declare that the interfering subject matter is subject matter that is not in all of your claims, but it's only in some of your claims, then you can have the board essentially cleave the rest of those claims and patents from the interference, and then they're no longer at risk. That was what the board was trying to do here. Another contingent motion to add count 3, which is on the next slide, same sort of an idea. A motion that designates most of those claims don't correspond to the count. The argument is you have to ask the board to do all the things you want it to do. And the fact that by substituting the count means that your claims don't correspond to the new count is not something that's going to happen automatically. You have to also ask the board to please do that. There's also a request for earlier priority date that goes back to December 12th and 2012, and you say, well, okay, but CDC wants to go back to May 25th, 2012, and the answer of why they filed this motion is it's not clear that CDC is going to get that motion granted. And it is clear that CDC has earlier dates of filing because they filed first. And the Broad's trying to get the earliest priority date it can so that it can stay senior party. This is all about the senior party designation because that gives them the advantage that I talked about before. And this is just proposed count 3, and I'm not going to belabor it. You can go over that at your leisure. The Bro's not done. It asks for invalidity judgment on CVC's claims for written description and enablement, and also 102 and 103. This was denied. And also that requires the CVC to keep the Broad and the board apprised of any other notice of allowance, and they denied that because that's their responsibility anyway. And again, motions for priority because that's always there. Okay, so the board did not give either party the right to file all their motions, but they did give the Broad the right to file its motion that CVC was stopped. And also contingent motion 2 to substitute the count, and motion 3 to designate claims not corresponding to the new count, and finally motion for priority benefit to the Broad's application from December of 2012. CVC filed a motion for its priority statement to be filed under seal, and that was denied, except that the board agreed that they would keep it not public until the priority phase. And this is something that the board is almost never grants these keep it quiet motions because their idea is this should be public and the public should be able to have access to it. And also the motion to be award benefit priority. So we're going to do the junior party. We're doing the senior party first this time. The Broad's argument in motion number 1 was that CVC shouldn't be permitted a second bite at the apple. Right? The idea was we had this interference before, that interference in favor of the Broad took care of all of the arguments that should have been made, and there was that interference estoppel, there was judgment estoppel for a claim that was raised or could have been raised, and it was CVC's strategic decision not to pursue these claims. Now, Rule 127 that I will now read to you because I forgot to give you a slide is the basis for which one of the sentences in Rule 127 controls is the issue between them here. It says, a judgment disposes of all issues that were or by motion could have properly been raised and decided, full stop. And the Broad's contention is that means that because CVC had the ability to file a motion to raise this issue of eukaryotic cell species and didn't, then they're stopped. The second sentence says, a losing party who could have properly moved for relief on an issue but did not so move may not take action in the office after the judgment that is inconsistent with that party's failure to move, except that the losing party shall not be stopped with respect to any contested subject matter for which that party was awarded a favorable judgment. Well, that makes sense. But this is now CVC's argument is that Rule 127 applies to losing parties. Broad, you were able to convince the Patent Office and the Federal Circuit that there was no interference in fact. Therefore, there was no losing party here, and because there was no losing party, Rule 127 doesn't apply to us, and the first sentence doesn't require this of a losing party. Right? That was the argument. The other thing that CVC says is judgment estoppel doesn't apply to the earlier interference. Interference estoppel might apply. However, Rule 127, as I just said, doesn't require that or requires that there be a loser, and there wasn't a loser. And why common law estoppel principles arose, I'm not so totally clear, but they also made that argument that there are common law estoppel principles that the office presumably is bound by, and that's another reason. And a lot of the Broad's brief use colorful words like remarkable a lot. And here they obviously believed it was remarkable that they would take that position in view of the Broad's interpretation of Rule 127 and they made an argument that we will not go into about how Rule 127 was related to old interference section 1.6858C, and like I said, we won't talk about that, but try to trace a legislative history, if you will, that would say this is what the Patent Office intended, not to have Rule 127 interpreted the way California wanted to. And their major sort of equitable argument is that CVC had the opportunity to add the claims in this interference to the earlier interference and didn't do so. And that was a strategic decision. That they didn't do it, they knew they should have done it, and they did it essentially to hold this back, to keep this, their hands behind their back, maybe with their fingers crossed, that this would be something that they would be able to spring on the Broad using their interpretation at this point and do exactly what they did. And that was wrong because it was a gaming, if you will, of the system. Now, who cares? Well, both parties care because, a decision in favor of the Broad's position here would end the interference. It would be done. And it would, status quo ante, you'd get back to, the Broad would get exactly back where they were before the second interference was declared, and that would be just fine. Okay. Once again, we're at this tracking purposes again, and don't have a different word. It's still patent, but please put that in your poll. And you'll get about 45 seconds, and I'll take a sip of coffee. And one of the fun things about interferences is that they are chock full of these sorts of strategic decisions, and determining what you can prove, what you can force your opponent to prove, how you can keep as many of your claims from harm's way as you can, and put as many of their claims in harm's way as you can. And so it's not exactly chess. I won't go that far, but I think it does sort of stimulate your strategic, whatever strategic acumen you may have. It stimulates that. Okay, so that is that. Senior party's motion number 2. It makes the distinction between a single RNA molecule embodiment and a double RNA molecule embodiment. And count 1 is directed to the single molecule embodiments. And the Broad wants to have a count that encompasses both species to give it its best proofs, right? And that's what it says. And the Broad's patents, these here, all of these, those are the ones that correspond to the count. That's not what the Broad wants to have happen, as I showed you a minute ago. They say its best proofs are related to achieving CRISPR in eukaryotic cells using the dual molecule embodiments they want. And here's the priority argument with respect to count 2. You can see that here is the Zhang provisional application from December 12, 2012. And all of these other patents and applications that come from these yellow boxes priority are all the ones that the Broad argues they're entitled to priority to that first provisional application, and that changing the count, substituting the count to count 2, because that's the count they chose, even though they had 2 proposed counts in their proffer to the board to be able to do that. But the count that they chose to assert in this motion is the one that the best proofs that they're entitled to that priority come from having the board grant the motion to substitute the new count 2 to this one. And CV says, well, it says proposed count 2 is too broad, and in fact, the way its claim is, the count is written, it doesn't have any requirement, any limitation that there actually be an effect on the targeted DNA. And they cite Lewis v. Okada, a 3-prong test about when there's a genuine need to change the count, and they say that, well, the Broad has, and to be fair, California uses some of these words like inexplicably a lot too. They've eliminated structural and functional limitations that actually make CRISPR what it is. They've eliminated requirements the complex have activity at the DNA level, and it just means it also is a product of the DNA molecule in unspecified ways, which means it reaches things such as RNA and protein, which have nothing to do with it. It's converted count 1 from a cell or a system claim to a method claim, and they've eliminated the alternative language of nucleic acid comprising a sequence here, and you can compare them to convince yourself of this. But that was their argument, and their opposition contains this handy-dandy little chart where it says in the left-hand column is CVC's part of count 1. And remember that count 1 is either claim 156 from one of CVC's applications or claim 18 of one of the Broad's applications or patents. And we can see here that the Broad PC2 or proposed count 2, according to CVC, says these are the count doesn't cover, and you can see the 2 white boxes for sure, doesn't cover parts of limitations related to CRISPR that the count when it was either CVC's claim or or the Broad's claim, that were covered the way the interference was initially declared. And so that deficiency in both having one limitation seemingly disappear and others that don't fulfill or satisfy with the specificity that the original count has, that means that that's the reason why the board should not grant the motion. The Broad says that it precludes reliance on dual molecule proofs, but puts at risk all of the Broad's claims. Right? And here it says that it wants the board to adopt count 2 to ensure that the claims are directed to a broad invention for use in eukaryotic cells. And who was the first to invent using CRISPR-Cas9, which, according to the Broad, is them. And if you don't do that, it'll be unjust and antithetical to the purpose, and all that incites the Eli Lilly case. So that's their argument of why the board should grant the motion. And here is an example of their best proofs. Right? And this comes from Figure B of an NIH grant application. Remember, it isn't just what's in the patent application. It's what's your evidence that you reduced to practice, constructively or otherwise, by what date? And here's an NIH, January 12, 2012 NIH grant application where there's a figure that shows the Broad's version of CRISPR. And they have the Cas9 protein on the left, plus the tracer RNA, plus the CRISPR array, which is a genomic target. And so it says, here are our best proofs that we used this unfused species, and the count should be broad enough to encompass that. And of course, the significance is if the board will adopt the count then and grants that motion associated with it about what claims are not corresponding to the count anymore, you would have most of the Broad claims not corresponding to the count, which is exactly what they want. For motion 3, claims not corresponding to the count, as I said, it's like that first decision of changing the count isn't self-effectuating. The board would also have to grant the Broad's motion about why. And here the basis is that these are all dual molecule claims, and count 1 was directed to single molecule embodiments. And so the single molecule embodiments, according to the Broad, should be a separately patentable invention. It's different enough to be a separately patentable invention. Separately, one thing it's an aside, but to be for completeness, the Broad also had a different species of Cas9, and also had claims about nuclear localization elements, things that would bring the species into the nucleus in eukaryotic cell that also don't correspond to the count. And I don't think there's a lot of argument that was certainly not expressly disclosed in any of California's applications. So that was part of this motion for completeness, but we're not going to belabor it. And CVC said, here's Rule 207b2 that says that, again, it's that standard of whether or not you would have anticipated rendered obvious. And according to CVC, the Broad hasn't satisfied its burden. It hasn't provided evidence. It has better proofs that it would be able to offer under count 1, and disregarding that argument that the Broad made a minute ago. And it assumes without proving that generic guide claims, which is what they're talking about, that would encompass both the fusion and the unfused ones, are patently distinct over the single molecule guide embodiments of CRISPR. And this is a valid criticism to the extent that under 207B, that would be what they would have to do to make that argument that these claims should be considered in a separate interference. Also inconsistent with the Broad's argument in its motion number 2, and the Broad cannot have it both ways is a nice way of putting it, talking about what's patently distinct over the other. Makes arguments about the expert testimony, some of it kind of biting. Also is stopped during arguments that were made in ex parte prosecution, and then it's Trump as well. If you're going to de-designate, remove the interference to Broad's generic guide claims, then you have to do the same, or you should do the same for ours as well, a sauce for the goose sort of argument. But of course, that's the last thing the Broad wants, because the Broad wants to get these claims out of this interference, not to set up for yet a third interference. And the Broad says, just reiterates what it says and says, well, your application of Rule 207 is rigid. And as I said, the significance is that if it gets its claims de-designated, it's fine, but if the CVC gets the same remedy, you may have yet another interference, which makes me think that it's unlikely that the board is going to grant this motion or any of these motions, because I think they probably want to get this done too as well. Motion number 4 is kind of the most interesting one. wants priority to this December 12, 2012 provisional application. And, of course, to do that, they have to show constructive reduction to practice, and that is example 1 of the B1 reference, right? That's what that reference is, the Zhang reference. He says, well, the problem with that is that you can't have a constructive reduction in practice because if you look at the chimeric guide RNA, the cell would have to make that chimeric guide RNA without undue experimentation. The actual chimeric guide RNA that is in that reference, in that priority document, has a mixture of uracil residues and thymine residues, and you can see it in that little cartoon that's on the lower right-hand corner. And the problem with that is that a cell doesn't make an RNA that has thymine residues in it, and so you can't say that this earlier provisional application satisfies the requirements that it's for 112 if you have a molecule that a cell can't make. And the Broad says, well, one of ordinary skin in the art would realize that these T's would be interpreted as U's, and the Broad has done a really good job in these interferences. But I have to tell you that just looking at that on its face, it's difficult for me to see that that is a winning argument because cells don't make things with T's and U's. And if you said, well, people would understand that we really meant to say a U instead of a T, it doesn't seem to me that it has a lot of force. But obviously for the Broad, if they were to get this motion granted, then they can continue to be senior party, which is the reason for this in the first place. So I think that we are in a situation here where of all the motions, this is one I don't see them, the board granting, and I'll probably be wrong. In fact, they probably handed something out today while I wasn't looking, but I just don't see that happening. So I think that the real question of who will be the senior party, and keep in mind, this all has to do with the priority phase. So if the board denies all this interference to stop on all those motions, and if we go on to priority phase, I think that if, again, a lot of ifs, if the board grants CVC's motions, we'll talk about in a minute, for its earlier priority date, then they would be the senior party. Speaking of which, this is their motion. The argument is that they deserve priority because they disclose both the single and double molecule CRISPR species. There's a prophetic example, in example 1, which they see as sufficient because there is no requirement for an actual reduction of practice, just a constructive reduction of practice. And in fact, although I don't think this really has a lot of weight, post-filing publications showed it actually worked, and that the understanding of the person of skill in the art would be supported by their expert testimony. And they have these examples, the embodiments, E1, E2, and E3 in count 1 of a fish cell, a human cell, and a fruit fly cell, where they say we show written description, not enablement in terms of we don't have an actual reduction of practice. We show how that would work, and it's supported by all these exhibits and all that. And all of this is online if you want to actually look for yourself and see what this looks like. And the Broad says, well, first of all, we did fact-finding in the earlier interference that establishes priority to our earliest provisional applications, and the board found that the skilled worker would not have a reasonable expectation of success in practicing CRISPR. And that position is actually the crux of the argument between the parties because the Broad is using the reasonable expectation of success standard, which is an obviousness standard, and CVC is arguing the right standard is the whether or not it would require undue experimentation to practice the embodiments of CRISPR that it's now claiming, given what was disclosed in the earlier application. We'll see that. The Broad says that you don't have an adequate written description in your earlier CVC in your earliest priority documents, and this is true that the only thing really that those earlier documents were disclosed were pretty much conventional methods of getting nucleic acids into eukaryotic cells. And there was really no specific disclosure related to practicing CRISPR because I think the idea was probably if you got it in, it would probably work, or that was the hope and expectation. And so they would say, fine, you've said what people knew all along. In order to get exogenous DNA into a eukaryotic cell, you have to do there are all sorts of things, electroporation and calcium phosphate precipitation, things of that nature. And you have to have a way for the eukaryotic cell to express those encoded sequences. So you have to have a promoter that would make CRISPR-Cas9 and be recognized as a transcription element, and et cetera, and all of that. But that's all of that was there. Was nothing new. Of course, since they hadn't done it, there was no basis for something to be new. And their argument is, look, the relationship between the obviousness standard and the reasonable expectation of success standard, that doesn't matter. That's a red herring, and that is basically what CV says in reply, that first of all you've misunderstood the blaze marks, the written description blaze marks that are in the specification. Right? You ignore them. That the Broad seems to be asserting a working example for written description, and you don't need that you don't need actual reduction to practice. Although, if you have a moment, there's a Biogen versus Mylan case. This is an interesting job of the interplay between 112 and 103 that came out of the District of West Virginia, of all places. And also, of course, the Broad's rationale is post hoc with no evidence of what the person of skill in the art would have expected P1 that they have to disclose unique conditions for using CRISPR-Cas9 in eukaryotic cells. And, of course, the main argument that Broad is conflating the obviousness standard with the written descriptions and enablement standards, and that's why the board should grant junior party's motion number 1. What would be the significance? Then CVC would get all these priority applications, and it would be senior party, and then going into the priority phase, the Broad would have to prove, subject to CVC's rebuttal, that it had invented first. For motion number 2, they say this is essentially the same arguments, but they say this is something that comes from our specification to show a priority document that shows constructive reduction to practice of the single. Remember, we're on count 1 because they haven't granted count 2 and the proposed count 2 yet. In count 1, it requires that they're fused RNA molecules there, and here this is what comes from our priority document, and that does both single and double-stranded, or sort of double molecule or dual molecule versions of practicing CRISPR in eukaryotic cells. So here's the evidence that we have, and the Broad says essentially the same arguments about priority benefit. And CVC just says if you look at the earliest priority document, it satisfies the requirement, discloses sufficient disclosure of the practice without undue experimentation, and this post-filing data supports that. And then this is the part where, I mean, if you read it, CVC gives, at least on paper, gives Dr. Merkin a pretty hard time because that expert, Dr. Merkin, he's an expert in nanoparticle technology, and says he has no expertise in CRISPR, and so you shouldn't give him a lot of deference. Patent law ain't for sissies. So there was an all-hearing that was virtual, and it was broadcast so we could listen in. And Broad spent most of his time, as you might imagine, arguing about substantive motion number 1, saying it's just the same reason that the board decided no interference in fact. Also argued that regardless, the board should deny the CVC's motions priority for the same reasons, and argues that if you look at the earlier fact-finding, wasn't applicable to reduction to practice because that's not what that interference had first was about, right? It was about whether it was obvious or not, and says that things like we can't relitigate the issue, I have an issue preclusion argument, and that neither priority document was considered in the earlier interference, and that argument's unavailing because there was nothing in those earlier applications that weren't disclosed in the earliest, the GenX 2012 reference. So in terms of the facts were before the board in the earlier interference, so there was no reason for the board to make any different decision here. The same the reasoning that the board used for non-obviousness or obviousness was relevant here because you have to have satisfaction of the written description requirement, and there's no bright line rule. Okay, so I mean, I will say that if you're reading the tea leaves, that the counsel for senior party, both counsel did an excellent job. He pretty much gave his whole presentation to the board without a question. It was a very, very cold bench, and the only question they asked was was really almost a housekeeping question. Where in the motions the senior party distinguished single and dual molecule embodiments? So there was really not much grist for that mill. CVC's arguments was simple, that the P1 application, its earliest priority application, satisfies the requirements for constructive reduction of practice, Therefore, you should grant priority. And in fact, we know that it was constructive reduction in practice because when people tried it, it actually worked. That the Broad's argument that you need a working example is not good law, and specifically, they argued that what was required was not the reasonable expectation of success, but the undue experimentation standard. They got slightly more questions for CVC's counsel than for Broad's counsel, whatever that means. Again, I'm not sure you can tell anything from the board because it didn't say very much. CVC's counsel did sort of miss an argument for at least making an equitable argument that, well, we invented CRISPR and that was the reason that they were able to do what they would do. There was an opening for something like that, which they didn't make. Rebuttal arguments were that by the Broad were that post-2012 experimental results was hindsight, and so that's irrelevant. They shouldn't consider that. And really, for the first time, it was interesting because I just said, and I said intentionally, that CVC didn't make the, you got it from us argument. But there was a hint of derivation, almost a hint that, well, CVC couldn't get it to work, almost by their own admission. And it was only after their scientists talked to our scientists that they figured out how to work, and there was no really factual predicate for that. CVC in rebuttal said the board's earlier decision in the interference was irrelevant. There was no authority that would let the board avoid priority issues here, and again cited Rule 127 for that failure to move, which was the best equitable argument that the board made. So we don't know what's going to happen yet, unless, as I said, the board came out with this decision while I wasn't looking today. So what happens in interference and what happens to the rest of us? Well, the board could easily rule consistently with its earlier interference, say no interference estoppel dispositive, then status quo, or CVC becomes a senior party, and then we'll have to see. The board could dissolve the interference on estoppel grounds, and if they don't do that, then the priority phase will happen in a few months. And as I said, whoever's senior party will not have to do anything, and we'll see what the junior party happens to do. Very briefly at the end here, because I think we have 5 minutes left, the risk to licensees is, first of all, this is just a thank you to the scientist. This is number of patent families, not patents, patent families, and you can see how it's just gone exponentially, although it's not 2018 and 19 are incomplete data. But you can see how the patent landscape is getting very complicated. Some of this has to do with different Cas9 or Cas embodiments. And this, I'm not going to go over this, but you should look at this as the licensing. And you notice there's really a break here. Berkeley and Vienna and Ménilmontant have licensed to the people on the bottom, and Mass General, Duke, Broad, Harvard, and MIT have licensed to the people on the top. And there's not a lot of crossover yet. There's a couple of places where they are, but there's not a lot. So just think about that for a minute. So recommendations, it's possible that the party will sue. It's impossible, really, that the parties will sue academic scientists. So to a certain extent, if you think about it, even Myriad didn't do that. And so to scientific progress, I don't think that this does much. Commercially, it's going to be a big deal. And there are lots of companies that are trying to develop these technologies, Editas, CRISPR Therapeutics, Caribou, Intellia. So I really do think that if I were their lawyers, I would say that freedom to operate is at least in doubt if they don't have licenses from both parties, which is never a good thing. Now, this is a little dated slide because, the difference between whether or not you have sovereign immunity to protect you. I'm less sure about most of what this says about sovereign immunity when it comes to IPRs and Berkeley, but to a certain extent, certainly the Broad will not have any immunity, and so no matter what happens, in fact, I would predict that if in fact you had California lose, that the next thing they'll do is file IPRs, and we'll see where that goes. And, I mean, theoretically, there's lots of money that was spent, and I have no idea, but the rumor is tens of millions of dollars were spent on this, which is much more than typical interferences. I think that settlement would be good for almost everybody. The benefits is certainty, obviously, and better technology transfer, and consistent with the Bayh-Dole Act. And I don't know, but COVID has made everybody very sensitive to the idea that the government can march in on these rights. And so I think that that's another thing to keep in mind. These are all universities involved here. and not only for them, but also the fact that there are many people who think that the whole tech transfer regime is a bad idea. I think they tend, in my opinion, they tend to ignore the facts. But the fact is that given this dispute, it certainly does raise the question of whether it's the most efficient way to do things. So I think, yes, almost right on time. I don't see any questions. That could just be me. But if there are any, certainly, ask. Let me see. Oh, I do have. Okay, there's lots of that. No, most of that sound check, so I don't really see any of that. So I want to thank you all for listening. Remember, you will get an email from Joe with the PowerPoint slides. You will get CLE credit. If any problem with that, contact Joe, not me. And it's just about 75 minutes, so I thank you all for listening, and have a good day.